Hello and welcome to Woodfork Law. Welcome to my law channel. And today I'm going to be talking about a few things that have come up in my law practice over the last week or two. And so I'm just going to be talking about a few legal issues that that might be helpful to you. So the first thing that came up is a legal theory here in Arizona, and I think it's all across the country, is called assumption of risk. And what assumption of risk means is that when you're suing somebody for negligence, you can't sue people for accidents that were expected to happen or that could reasonably anticipated that happened in the activity. So the best example of this is like in sports, where if somebody gets accidentally elbowed in the nose, or somebody gets crashed in a bike race, or somebody gets they lose a tooth in a hockey game, something like that, you can't sue for those things because as a victim in that scenario, you assume the risk of that elbow or whatever. And so if that was outside that context of the sporting event, say on the street or something, and there's a fight or something like that, then that type of injury, the fight wouldn't be really that because that's intentional. But if there's an accident, you can't sue for an accident if you were the victim exposed to something that was reasonably expected. And so I don't see a lot of those type of cases here in my law practice, but the legal theory is out there, and it is a good defense for the insurance company if the issue does present itself. And so that's one legal issue that came up. Another legal issue that came up is that the wage loss document that insurance companies want car accident victims to sign. I talked about this in a previous couple videos before, like not to give a statement and not to sign a medical release, but also don't sign any type of wage loss release that comes in the mail or by email or anything like that, because the insurance company wants you to write down who you're working for, how many hours you're working, how much you get paid per hour or per year, and so they want to know like how long you've been on the job and what your salary is. Now, wage loss is something that you're compensated for in a car accident case, but you're going to be able to provide that to the insurance company later from your own lawyer. Your own lawyer is going to get that information together and send that to the insurance company. You don't want to sign their form because they'll send it to your employer and they'll try to get the information before you. And sometimes they even try to get the past employers, like the last 5 years of places you worked with, to try to find out your like work history, how consistent you've been working, things like that. So like I said before, you don't want to give them carte blanche basically to go through your work history or work past. You can provide that information at a time of your choosing later on in the case. And so another thing that we dealt with a while ago was, and I didn't think I'd have to be dealing with this in 2022, but when you're involved in a car accident and you're claiming injuries and you're hurt, don't post videos and pictures and things like that on social media showing you doing activities, basically showing you're not hurt. I've literally had cases, not so much recently, but back, when not cell phones first came out, but when video first came out and people were filming everything and taking pictures of everything, you would always have like the insurance company go in and looking at people's public social media to find out if they've been doing any activities while they said that they were home laying on the couch hurt. And again, it seems kind of obvious. It seems, if you're saying you're hurt, you're not going to post the pictures of you out water skiing or, I don't know, wrestling alligators or something. It's just like, just kind of stay off social media, or to the extent of, just remember, if anything's public, the insurance company's investigators will go through that and look for, any of that information. So keep that in mind. And then also another thing, going back to the wage loss information, as far as not signing the form, One of the things that comes up, like I said before, we're going to supply that information to the insurance company at the end of your case along with your demand package. But a lot of times it comes up where people have to prove how much money they lost because of their injuries. But if they're not working at a job, if they're not an employee or they work for themselves, proving how much money you lost is more difficult than it is if you just are an employee at a company. So what happens when you're a self-employed person or entrepreneur and you're claiming lost wages? Normally what we do is we'll get like the last 1 or 3 years of taxes to show how much money you've made every year. Or we'll look at things like invoices from people who've hired you for jobs that they had to cancel because of your injuries because you couldn't work. We'll get proof of that of customers basically who said that they couldn't hire you because you weren't available to work. Things like that. We look at your schedule, we look at your diary, like your work diary kind of, all your scheduled jobs, and then kind of like where they stop because of your car accident, because of your injuries. So all those kind of like piecemeal things we put together to prove how much money you lost because of the injuries and because you weren't able to work and you weren't able to do things. Again, it's a lot harder than if you're just an employee. When you're an employee, you miss 2 weeks of work, then you just go to your human resources department and say, I lost 2 weeks off of work. Here's what I usually make. Here's the hours I usually work. And then you get that money back from the insurance company. So that's another issue that comes up as far as self-employed people who are trying to prove wage loss. The other thing that came up is what's called the offer of judgment. And the offer of judgment here in Arizona is pretty interesting. It's basically a losers pay law. And so, when people complain about personal injury lawyers and people complain about, everybody being sue happy, they don't understand that in Arizona, at least, and probably across the nation, there's a law that basically says that at some point in the lawsuit, the insurance company can offer to settle with the victim, and they send it over in writing. And after that kind of starts a clock. After that day that they send over what's called offer of judgment, their offer to settle, they send it to the lawyers, to the plaintiff's lawyers, to the victim, and then they also send a copy to the court. And this is all after the lawsuit starts, by the way. And so they send the offer to judgment to the victim and to the victim's lawyer and to the court. And so after the court gets it, anytime after that, any type of cost, any type of fees that the defense side has to spend, if they have to spend money on experts, if they have to spend money on reconstruction, accident reconstruction people, all the money that they have to spend after that offer of judgment, if you go to court and you go in front of the judge, arbitrator, jury, anything like that, if you get less money than that paper that they offered you the settlement with, if you get less than that at the end, then you have to pay the other side's cost for the experts and reconstruction and all that. So there is a big risk actually when you get an offer of judgment as a plaintiff's lawyer, because you really have to consider whether or not you can get more later in the case than what they're offering you now. But again, that's called an offer of judgment, and that's what kind of stops frivolous lawsuits, because that if you get less from a jury or from a judge, you're going to be on the hook for, could be tens of thousands of dollars in fees to the defense lawyers for defending the case. So that's another concept in Arizona, and again, I'm pretty sure it's pretty in everywhere else in the country too, in some way. And that and then also what connected to that is what people always think, that personal injury cases always settle. Now it is true that there's probably, I'd say 90% cases, maybe 95% cases actually settle in that they don't go to trial, they don't go to the jury, and the jury doesn't come back with a verdict. I would say that happens only maybe 5% of the cases, maybe 3% of the cases at most. What happens normally is probably 70 to 80% of cases, at least in my experience, and 70, 80% of the cases, they settle without having to go to court at all. You negotiate with the insurance companies, you settle the case, and you're done. But there's about 20% of the cases where you actually have to file the lawsuit in court because the insurance company hasn't given you a fair settlement offer or some other reason. But there's about 30% of the cases that actually get filed in court, and then in the course of the litigation, as far as preparing to go to trial and all that could take a year, 6 months, whatever. In the course of that, most cases do settle. And so, like I said, and the ones that actually go to trial are very few and far between. But it's not an insignificant amount of cases actually do end up in court, but they usually settle. Usually they settle after the victim's deposition. Once the victim sits down with the defense lawyers and gives them a statement, usually after that, that's when settlement talks usually get really going, and cases usually settle pretty shortly after that. But usually that's, like I said, about 6 months after the lawsuit was filed, but they do settle. And then also, kind of along that the settlement avenue is there's a common rumor out there that personal injury cases all settle for 3 times medical bills. That's not true, and not in 2022 anyway. When I first started practicing law back in 2001, that was kind of true. I mean, you could count on, if you had a personal injury case, you could count on getting about 3 times medical bills, a settlement offer from the insurance company. But these days, it's not like that. I mean, depending on the case, sometimes you just get $2,000 or $3,000 on top of the medical bills. Sometimes you get 4 times medical bills. There's just really there's no rule of thumb basically on 3 times medical bills. I'm not sure where that came from. Well, no, I take that back. I mean, it was kind of true back in the early 2000s. But at some point in time, the insurance companies basically stopped settling cases like that. I mentioned before they use the computer program called Colossus, where they put your medical bills in it, and that kind of kicks out the value of the case. And that's, once they started using all that information, then they stopped just giving 3 times medical bills out of course. But unfortunately, I mean, 20 years has passed and things have changed. But again, if you're involved in a car accident these days, don't count on just walking in there and getting 3 times your medical bills. So again, I hope that helps. Like I said, those are all kind of things I've been dealing with for the last couple of weeks in my law practice. If you have any questions, if you need any more help, check out my newsletter in the description, and give me a call. I'd be more than happy to help you out. Thanks for listening.